This is just one court order from a federal district court, one of the many lower courts established by Article 3 of the Constitution of the United States of America. It is only one page long, but within the four corners of this parchment is the destruction of this country and our way of life. On January 15th, 2018, the Honorable Claude Hilton stated on behalf of the Federal District Court for the Eastern District of Virginia, Alexandria Division, there is no procedure to remove a state criminal action to a federal court. This simple statement should send chills up the spine of any person who has endured the first year of law school and both civil and criminal procedure classes. Because since Reconstruction, there has always been a procedure codified in federal law to remove a criminal action from a state court upon an infringement of a federal statute that protects a specific right, and it has generally involved discrimination on the basis of some demographic distinction. And as late as 1978, these statutes were still being utilized to gain acquittal for African Americans arrested for trespass after forcing integration at a lunch counter. 28 United States Code Section 1455, with the popular name of Procedure for Removal of Criminal Prosecutions, and last updated on December 7, 2011, states specifically at paragraph B3 that the filing of a notice of removal of a criminal prosecution shall not prevent the state court in which such prosecution is pending from further proceeding, except that a judgment of conviction shall not be entered unless prosecution is first remanded. Yet the petitioner was convicted in absentia by a Commonwealth attorney and a presiding judge who claimed that they had waited for 45 minutes for a criminal defendant who had no notice that he was supposed to appear, was convicted in absentia on what appears to be inadmissible hearsay evidence that is presented further in perjury, a fact corroborated by the surveillance video in the possession of the prosecution, but for which that court engaged in willful blindness not to review. Moreover, not just one, but two requests for reopening of the matter for retrial have been flatly refused. Further, 28 U.S. Code Section 1455, with the popular name of Procedure for Removal of Criminal Prosecutions, and last updated on December 7, 2011, states specifically at paragraph B4 that the United States District Court in which such notice is filed shall examine the notice promptly. If it clearly appears on the face of the notice and any exhibits annexed thereto that removal should not be permitted, the court shall make an order for summary remand. But this petition was filed with the Federal District Court in Alexandria on October 4th, 2018, reputedly the first removal petition filed in over 30 years, a fact that created immediate confusion at that court, which even initially assigned it a civil matter number instead of a criminal matter number. And this decision of the Federal District Court was not handed down until January 15th, 2019, over 3 months after filing on claim of that court having proceeded with all deliberate speed. And it is noteworthy, in a reportedly godless jurisdiction, that discrimination was not based on color, not based on gender, not based on any other factor other than religion. Yet this is not an isolated miscarriage of justice in contravention to a rule of law. A Federal Circuit Court of Appeals in Virginia and the District of Columbia have nullified an enactment of the Congress, the All Circuits Review Act, sponsored by Democrat Elijah Cummings, but signed by President Donald Trump to expedite the adjudication of Whistleblower Protection Act claims currently awaiting hearing before the Merit Systems Protection Board, which lacks quorum to hear those cases involving government waste, fraud, and abuse. And in this action, implicating both Congressman Donald Byer and Senator Tim Kaine in the offer or attempted offer of a bribe to a conservative running for U.S. Congress. A former candidate currently in a petition for a protective order on appeal in which Senator Kaine has retained the best political law firm in the country by reputation to dismiss, and alleging that he employed or retained or acquiesced in the use of an internet troll who operated in clear violation of federal law, Class E felony, and is chargeable by up to 218 counts, eligible for fine and up to 2 years in prison for each offense. An offender who currently remains at large with impunity because even the Commonwealth Attorney will not attempt to charge that individual. A Virginia Circuit Court of Record has declared that a complaint that was filed and alleging a tortious interference with a business expectancy for a public advocacy or political campaign, a cause of action recognized in many other jurisdictions, was brought without any basis in fact or law, and decreeing that the filing of the complaint should be cited. That same complaint, as to other defendants named, has been quashed on claims of defective service because the defendant claimed that the incompetent sheriffs served process on incompetent secretaries, and the attorney only discovered of the existence of the complaint when he happened to be at the courthouse on another matter and happened to look at the docket, and rather than obtaining a copy of the pleading while at the courthouse, he chose to quash the complaint for defective service and non-receipt. Despite the fact that the entry of a general appearance in a matter waives the defense of the lack of notice, that motion to quash the complaint was granted by that court, and like other matters, it is now on appeal, despite the fact that that attorney and the attorneys who replaced him were paid with public funds to defend a Democratic Party endorsed, Act Blue funded political campaign under defense of sovereign immunity. Yet these actions by persons above the law are not being conducted by or on behalf of a deplorable and not my president who wants to make America great again, but by proud progressive Democrats who delivered the Commonwealth of Virginia to Hillary Rodham Clinton, the only state of the former Confederacy to do so. These are the educated and enlightened voters who have called for removal of monuments to the Confederacy, sent 4,000 activists to oppose less than a dozen people in D.C. who they accused of spewing hate, who reject school choice because it is alleged to promote segregation and seek only a profit motive, who broke records and protest numbers to support the choice of abortion for the poor and persons of color, who reject a wall to provide national security and establish sanctuary cities to open our borders to even the vilest criminals and terrorists, and who deny the existence of God in heaven because their claims of science are supposed to be the distinction of intellectuals. And now they control one house in the Congress and are pushing for more with the support of a progressive press. I do solemnly swear that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear true faith and allegiance to the same, that I take this obligation freely, without any mental reservation or purpose of evasion, and that I will well and faithfully discharge the duties of the office on which I am about to enter. So help me God. Not unmindful of the future is the motto of Washington and Lee University. My name is Major Mike Webb, and I am running for U.S. Congress in liberty, with honor and excellence. The South shall rise again. Honest.
This advertisement was authorized by Mike Webb.